Welcome to another episode of The Dissection. Today, there was a major constitutional court judgment that was handed down in the Vodacom versus Makate matter. And the ruling was a major setback, if I'm being honest, for Mr. Makate, in that the court sent the matter back to the Supreme Court of Appeal, asked for a new panel of judges to adjudicate the matter, and potentially, if Makate wins again or gets a large quantum awarded by the second process of the Supreme Court of Appeal, Vodacom still has an option to come back to the Constitutional Court again. So, in case you haven't been following the story, Vodacom was challenging a ruling by the Supreme Court of Appeal from last year that Kenneth Makate, who is their former employee, be paid between 29 billion rand and 63 billion rand for a callback service idea that he proposed to the company's product development team when he worked in its finance division in the early 2000s. And they were successful today in that they will get another bite at the cherry. They'll get to re-argue some of the arguments that they had already made in the Supreme Court of Appeal with a new set of judges. So this is what was said today by This is what was said today by Justice Madlanga in a unanimous judgment of the Constitutional Court.
Deciding them, purely to demonstrate the Supreme Court of Appeal's failure to comply with the duty of proper consideration. We cannot suddenly be at large, as the legal language says, to determine those factual issues. The matter must be remitted to the Supreme Court of Appeal for a proper determination of the appeal. And that must be before a differently constituted panel of the Supreme Court of Appeal. The court makes the following order. 1. Leave to appeal is granted. 2. The appeal is upheld. 3. The order of the Supreme Court of Appeal is set aside. 4. The matter is remitted to the Supreme Court of Appeal to be reheard by a differently constituted panel of judges of that court. 5. Each party must pay their own wasted costs in respect of the abortive hearing of the matter in the Supreme Court of Appeal. 6. The first respondent must pay the applicant's costs in this court, including the costs of 3 counsel. I hand down the judgment.
We're all still waiting for the full judgment to come out, but I can make some preliminary comments about my thoughts on this. So as things stand right now, this could go on for another 2 years at this point. It could go on for another 3 years. And because of that, I think it's truly a disappointing outcome. Even if the court found that the Constitutional Court found that the Supreme Court did not take some of the arguments made by Vodacom into full account, if they find that they over-relied on Makate's version and evidence as opposed to the countervailing evidence presented by Vodacom, I think that they should have examined those issues and made a final determination on this matter themselves so that this issue could have finality. Because as things stand right now, this is yet another delay in the resolution of this matter. The litigation has been going on since 2008. Since 2008. We're approaching 20 years now when this man has been in the court. What happened to justice delayed is justice denied. I don't know if this man has children, but I can't imagine what it's like to be running in and out of courts for close to 2 decades because some man at the big company have resolved never to pay you a cent. And it's beginning to look like there is a decision that was made somewhere in the corridors of Vodacom that we're going to take this idea and we're not going to give this man a cent and we're going to frustrate him till we die. He is going to die without getting a cent. It feels that a decision was made. Because if you think about this, let's go back a bit. In 2016, this matter was at the Constitutional Court. 2016 is almost 10 years ago now, 9 years ago. The Constitutional Court ordered the following. The Constitutional Court declared that Vodacom is bound by the agreement which was concluded between Mr. Kenneth Nkosana and Mr. Philip Gisa, or however you say, Gisla. I don't know how to pronounce his name. So Vodacom was ordered to commence negotiations in good faith with Mr. Kenneth Nkosana Makate for determining a reasonable compensation payable to him in terms of the agreement. In the event of the parties failing to agree on the reasonable compensation, the matter was supposed to be submitted to Vodacom's chief executive officer for determination of the amount within a reasonable time. I think that was the mistake there. They should never have sent this to the CEO of Vodacom as if he's a neutral, independent arbiter in this issue. He's a continuation of other CEOs who tried to steal this idea from Vodacom and may very well have had conversations with them where they say, don't pay this guy a cent. Right? And then Vodacom was ordered back then to pay the cost of the action, including the cost of two counsel and the cost of the expert who presented at the Constitutional Court. And the negotiations were meant to commence within 30 calendar days. And that was supposed to be the big moment where Vodacom would make a deal with Makate. But we are now in 2025. And as you can see, the Vodacom people are running from pillar to post. They don't want to pay that money. They don't want to pay a cent. We've reached 2025 and the issue is still ongoing. And one thing I want to point out, and what we must be clear about, is that the contract was entered into between Vodacom and Makate. They entered into a contract. They made billions from his idea. They made billions. There was an agreement between the director of product development. There was an agreement between him and Vodacom and Makate. And there was an understanding that Vodacom would use his idea to develop this product, which would be put on trial for commercial viability. And if the product was successful, the applicant would be paid. In that original case that was at the Constitutional Court, Makate was the applicant. He would be paid a share in the revenue generated by it. And when they were negotiating in the 2000s, Makate had indicated that he wanted 15% of the revenue. They didn't finalize that, but they said, we'll come back to the issue after the pilot of how much you should get, right? He was supposed to get resolution on that issue. But it looks as if at some point, Vodacom's chief executive officer decided that he was going to hijack the idea, take it as his own. They launched the product. The product was a success. It made them billions. Despite the product being a success, Vodacom did not negotiate compensation for the use of Mr. Makate's idea. Instead, what happened? And the High Court actually spoke about this and they were so disappointed. Mr. Not Craig, who was the CEO and the product development manager, created a false narrative about the idea of where the Please Call Me product came from. And it got so much that even in the autobiography of Mr. Not Craig, he claimed that it was his idea. He said that the Please Call Me idea was his idea. That's preposterous. How can you do that, sir? Vodacom, in my view, is acting as a corporate bully. Because what's happening here is David versus Goliath, and Vodacom is Goliath. And they're doing things to frustrate this man. They want this man to die without getting that money. Let's be clear. Vodacom can end this matter anytime they want by giving Mr. Makate a fair offer. He proposed 15% of the revenue when he made the deal in 2001. Let's assume 15% is too high. And let's say he deserves 2% for the idea. If the company made 20 billion with the Please Call Me idea, that means he's entitled to 400 million rands. Let's assume that they had offered him 400 million rands. I don't think he would have walked away from that deal. I think he probably would have taken it, 500, maybe even a billion. I think he would have taken that money because they made more than the 20 billion that I suggested. And there was a contract. They entered into an agreement with him. The way Vodacom has been moving suggests to me that they have not been acting in good faith. And I think that's something that the Constitutional Court should have taken into account, to say you guys have not been operating in good faith since our 2016 judgment, and then act in ways to resolve this matter in a manner that protects contract law and upholds the contract, in a manner that upholds small players who have brilliant ideas that make big players billions, in a manner that actually restores the trust in the judiciary, in the Constitutional Court itself. Because right now it's looking as if there are certain individuals who can get away with whatever. You know, if their surname is Ramaphosa, if their company name is Vodacom, it looks as if the courts are willing to bend over backwards to accommodate them, to stretch understanding of the law. But when it's somebody like Zuma, the court is willing to send him to prison, right? And even stretch their understanding of the law in order to fit that particular outcome. But it's beginning to look as if Lady Justice is not necessarily blind. She's squinting from underneath that particular blindfold and seeing who the litigants are in issues. And they have to be aware of that and sensitive to that. I mean, let's acknowledge how wild it was for the CEO to claim the idea as his own in the 2000s. That's already a show of bad faith. Having the audacity to claim in your autobiography that you invented the product is shameless. Even the courts found the former CEO, Alan Craig, not to be a witness who was not credible. They didn't find him to be a credible witness at all. This is why even now I'm concerned that we keep acting as if the CEO of Vodacom is this unquestionable authority, as if he came down with Moses with a tablet from the mountains and read us the commandments. He's a man motivated to maximize Vodacom profits, to tell the version only from Vodacom's side, which is why I think perhaps the Supreme Court didn't take his arguments as being genuine or didn't necessarily give them the due regard. Maybe they also found that he wasn't being a credible witness. It's unfortunate that they didn't discuss that at length in their judgment, because that is what now has led to the Constitutional Court saying, start again because you didn't address this, that, and the other. But I don't think that there's been good faith from Vodacom in the way they've acted. It looks to me like from the onset, they decided that they would frustrate this man through the use of the legal system. They wanted to make an example of him to Vodacom employees, to let them know you will not get a cent from us for the ideas that make us money. Just take your paycheck and be happy. This decision to use what has been often called Stalingrad method by one of the largest companies in Africa and South Africa against one man, it shows to me bullying, it shows intimidation. I mean, Vodacom even last year went to the media and started saying various things which showed me a lack of appetite to pay Makate. They started saying, well, this guy can't just become a billionaire. No, if we pay this man, your calls will go up, data will become more expensive. Then they said, yeboye to shareholders will not make the dividends. They came up with a lot. And there were some publications which were willingly repeating those narratives unquestioningly and just repeating what Vodacom wanted them to say. They started a smear attack on Makate, talking about who invented, please call me who's the real inventor. That wasn't even the legal issue anymore, because there was an agreement in 2001 between Vodacom and Makate. The agreement is the issue that now needs to be enforced. The offer of 47 million itself was an indication to me as bad faith. It came across to me as lowballing the man, forcing him to go back to the courts so that they could continue to delay the process and drag it out. You know what? The media has trained me that people who use delaying tactics in court are playing Stalingrad strategy. And what they have said about such people is that they are unethical, they are abusing the system. This is what they were saying about Jacob Zuma. Do you remember? They say Jacob Zuma keeps avoiding court. He's guilty. Why does he keep using delaying tactics? That's what they said and continue to say about Jacob Zuma. Let's assume that logic is fair and correct. How is Vodacom any different to Zuma? Are they not using Stalingrad methods? Are they not frustrating this man because they know that they've got limited resources and he has limited time on earth and also limited resources? Really, so frustrating what's happening here. You know, I don't think that justice is being seen to be done here. I think what we are seeing is justice being delayed over and over again by one of the most powerful companies, which continues to make profits. By the way, also Vodacom just seems to be getting as they please, because the Competition Tribunal found that their merger was not a merger that should go through with Maziv, the one which owns Vumatel and Dark Fiber Africa, because they're trying to consolidate that internet space, and Vodacom and Maziv now are going to be a duopoly controlling, internet, fiber internet, as well as, fiber internet and cellular internet, because Vodacom is the biggest player in that space. And now with Maziv, which is the biggest player in fiber, they're basically going to be controlling this whole thing. And they were able to get that tribunal outcome frustrated because they went back and they made some deals, and now the merger is going to go ahead. So Vodacom seems to be working behind the scenes in funny ways, man. I don't know. What do you think about this judgment? Do you think Makate will ever get his money? Do you think he should have settled for the 47 million? Was that enough? Was that fair? Do you think that Vodacom is abusing the process? Let's have a conversation in the comments. I'll meet you there.